Hello there, I'm Black Bright News, and I don't know how many of you have heard about this proposal that David Lammy's come up with to get rid of juries for lower level cases. It's not written into law or anything yet, but I wanted to share some of my thoughts with you, the implications and maybe the advantages and disadvantages of it, and whether there are any advantages or any disadvantages. So let me just run it by you without digressing by reading my script. So, when you first hear the government talking about removing juries from lower level criminal cases, it can sound almost reasonable, practical even. The courts are overwhelmed, the backlog is growing, victims are waiting too long, defendants are left in limbo, something has to give. And so the language shifts from efficiency towards speed, towards streamlining, words we've become very familiar with in modern life. But then you sit with it a little longer, and if you've ever served as a juror or spent long days waiting in a courtroom, you realise that the problem hasn't been a lack of willingness from ordinary people. Jurors turn up. I know it's usually under threat, but they turn up, they sit, they wait, they're ready. What often isn't ready is the system itself. Files aren't where they should be, cases are adjourned, witnesses aren't available, you're sent home again and again. Not because justice no longer needs you, but because the machinery around you can't quite keep pace. That experience changes how you hear these proposals, because when you've lived in the delays, you know instinctively that juries themselves are not the main obstacle. They're not the reason the system is slow. They're simply the most visible part of it. And so when the solution focuses on removing jurors rather than repairing the deeper faults like staffing shortages, administrative breakdowns, under-resourced courts, it raises a quieter question, not an angry one, just a thoughtful one. What exactly are we fixing here? For alleged offenders facing lower level charges, the promise is speed. Cases dealt with more quickly, fewer months of uncertainty, fewer delays. On the surface, that sounds humane. But it also means their guilt or innocence is decided without a jury of peers, without that collective, communal judgment that has long been part of how society weighs truth. A single judge may be fair, experienced, and careful, but something subtle shifts when justice becomes something delivered to people rather than shaped with them. And for the rest of us, the ordinary people who make up juries, it changes our relationship with justice itself. Jury service has never been easy. It costs time, energy, income. The compensation is modest, sometimes symbolic, but it has always carried meaning. It's one of those few moments where everyday citizens step directly into the process of deciding truth, not as experts, not as professionals, but representatives of the community. So when we hear that juries may no longer be necessary for certain cases, it's worth pausing over the logic behind that. We're told it's about efficiency, about prioritising resources, about focusing communal effort where it matters most. And perhaps there's truth in that. But across many areas of modern life, we see a similar pattern emerge. Systems quietly moving towards speed and optimization. Professionalising decisions that were once shared, not out of malice, but out of pressure. The risk isn't that justice becomes unjust overnight. The risk is subtler than that. It's that participation begins to feel optional. That some cases, and by extension, some people, are considered too small, too routine, too minor to warrant the collective voice of the community. And once that idea takes hold, it becomes easier to accept without ever consciously choosing it. This is where truth itself can feel partisan. Not because the facts change, but because the framing does. One side speaks of crisis and necessity, another speaks of tradition and rights. The same backlog figures are used to tell different stories. And for those who've actually sat in those courtrooms, waited those long days, given their time freely, the lived truth doesn't always fit neatly into either narrative. You start to see that delays weren't caused by juries being slow, but by systems stretched too thin. That removing juries might free up some space, but it won't repair what's fundamentally broken. And you realise that what's being negotiated here isn't just time, it's the nature of justice itself. Whether it remains a shared civic act or gradually becomes something more streamlined, more managed, more distant from the people it serves. None of this requires outrage. It doesn't call for rebellion. It simply asks for attentiveness, for the humility to notice what changes when we prioritise efficiency over involvement, even for good reasons. Because justice has never only been about outcomes. It's always been about process, about who is invited into the room, whose voices matter, and how we decide what is worthy of our collective judgment. And perhaps the most important thing your experience teaches us is this. Perhaps the most experience